Good morning, class. This is Miss Formy-Duval, and today we're going to talk about civil rights. Our definition of civil rights is going to be the rights of people to be treated without unreasonable or unconstitutional differences. And in the 50s, it's going to start working its way into the courts. But prior to that, blacks are going to, face awful segregation with separate facilities, which the court ruled was constitutional up until 1954 in the Brown decision. In 1954, Brown versus Board of Education was a Supreme Court case and ruled that separate but equal was unconstitutional. And we all know that case. It integrated the schools, but not immediately, the court said, with all deliberate speed. When the court was trying to determine this case, they had a three-part test that they worried about: implementation, rationale, desegregation versus integration. I have a slide for each one of those. And you'll see here the campaign in the courts prior to being very vocal in the courts and trying to get their voice heard at the courts. They really tried through legislation in Congress. That did not work, so they moved from Congress to the courts. Okay, here's a picture in Charlotte, 1957. And she is trying to go to a high school in Charlotte, and she's being taunted by these white kids in the background. Dorothy's the first black student to attend Harding High School in Charlotte, and she's trying to maintain her poise while these white kids are shouting at her and gesticulating and just really giving her a hard time. Just put yourself in her shoes at how hard that would be. Okay. Implementation. How's that going to work? Alright. This is a picture of Governor George Wallace of Alabama. He's standing at the door of the University of Alabama, and this is the Assistant U.S. Deputy Attorney General, and what's going on is the governor is blocking entrance for black students at the state level, and here we have at the federal level saying, oh no, you have to do this.
In the name of the greatest people that have ever trod this earth, I draw the line in the dust and toss the gauntlet before the feet of tyranny, and I say segregation now, segregation tomorrow, and segregation forever.
And as you can see, that was the mentality in the Deep South. Also in some not so deep, North Carolina, Virginia. Okay, desegregation versus integration. Anti-busing protesters buried a school bus, nobody was in it, to dramatize their causes as far as busing is concerned. Busing to integrate. So the court's thinking, if we desegregate, we need to think about all the problems once we do that and how states are going to integrate that with all the resistance. Okay, here's the campaign in Congress. And basically it's all about civil disobedience. These three guys were students at North Carolina A&T University in Greensboro, and they are doing a very peaceful protest, sitting at a lunch counter at Woolworths, very dressed up, okay, but they're trying to be non-violent. In 1960, black students from North Carolina A&T, they were refused service at a lunch counter. 20 years later, graduates of this college returned to the same lunch counter. And here, the prices had risen, the service had improved. So it was started out with three guys, and they would sit for a few hours, and they would have replacements, and we have more and more and more people. Civil disobedience. Alright, things are going to start to get really nasty late in the 1950s and early 60s. Okay, civil disobedience, there were lots of sit-ins, sitting on the sidewalks, and state and local governments would send in their law enforcement officers with German Shepherds to bite these protesters. Absolutely awful. Okay, here's a picture or a caption here This was in 63. The picture of a police dog lunging at a black man during a racial demonstration in Birmingham, Alabama, 1963. It was one of the most influential photographs ever published. It was widely reprinted throughout the world and was frequently referred to in congressional debates on the Civil Rights Bill of 1964. The Civil Rights Bill of 1964 was an awesome piece of legislation signed by President Lyndon Johnson. In 64, there was a Democratic landslide in the executive and legislative branches, so it was a lot easier to get legislation passed. Okay, this is the famous I Have a Dream speech. 1963, this is the 100-year anniversary of the Emancipation Proclamation, and Dr. Martin Luther King Jr., who led the Southern Christian Leadership Conference, he didn't pick a random date. He made it 100-year anniversary to prove still segregation in America after 100 years. All right, interesting table here. Increase in the number of black elected officials. We're going from 1970 up to 2001. So here, it starts at the bottom, local boards of education, all the way up to Congress and the state legislatures. But you can just see locally a dramatic increase of African Americans elected to public office. That's a huge deal. All right, women and equal rights. Supreme Court standards. They always have to have a standard on what they're looking at. Is it reasonable? And they have intermediate scrutiny and strict scrutiny. Some discrimination they're going to determine is illegal, some not. They're also going to make decisions allowing differences based on sex, sexual harassment, privacy, and sex. Okay. Here are standards. This is how the court decides if you discriminate. The Supreme Court has produced 3 different tests to determine if a government policy produces unconstitutional discrimination. Don't be surprised if you find it a bit hard to tell them apart. Number 1, the rational basis. If the policy uses reasonable means to achieve a legitimate government goal, it's constitutional. Here are our examples. If the government says you can't buy a drink until you're 21, this meets the rational basis test. The government wants to prevent children from drinking, and age 21 is a reasonable means to decide when a person is an adult. And a state can ban advertising on trucks unless the ad is about the truck owner's own business. Intermediate scrutiny here serves an important government interest and is substantially related to serving that interest. Here's the example. Men can be punished for statutory rape even if women are not punished because men and women are not similarly situated. And men can be barred from entering the hospital delivery rooms even though, obviously, women are admitted. That was a little old school. Now I think men do go in the delivery room on occasion. Strict scrutiny. To be constitutional, the discrimination must serve a compelling government interest. It must be narrowly tailored to attain that interest, and it must use the least restrictive means to attain it. And the examples here, distinctions based on race, ethnicity, religion, or voting must pass the strict scrutiny test. You cannot bar black children from a public school or black adults from voting, and you cannot prevent one religion from knocking on your door to promote its views. Okay. Excuse me, I skipped that previous slide for a reason. Okay, we're going to deal with court cases that are dealing with privacy and abortion. And it's going to start out here in 65 with the Griswold case. The court found a right to privacy in the Constitution that would ban any state law against selling contraceptives. I know that probably sounds very hard to believe. 65. I guess in your world that was quite a while ago. We all know the Roe v. Wade case. Excuse me, that just said that state laws against abortion were unconstitutional, and a woman has the right to have an abortion the first 3 months. Okay. In 89, the Webster case, it allowed states to ban abortions from public hospitals and permitted doctors to test to see if the fetuses were viable. Planned Parenthood v. Casey, it reaffirmed the Roe decision, but it upheld certain limits. And finally, in 2007, the Gonzalez case, federal law may ban certain forms of partial birth abortions. So, kind of getting a little bit more strict. Okay, affirmative action. This is dealing with we talked about in class, a guy named Alan Bakke, who applied to med school. White guy, didn't get in. His grades were higher than a black guy, and so he's going to sue. That's the Bakke case. And when the court's talking about affirmative action, equality of results is what they're going to be thinking about, making certain that people achieve the same result. Some people call it reverse discrimination. That's when you use race or sex to give preferential treatment to some people. Equality of opportunity. Everybody has the same chance to succeed. The results are the same as up here, but they have the same chance. Okay, we got a little photo going on here. And this is going to be a demonstration in Georgia over immigration laws. So we started out with African Americans, women, reverse discrimination, some call it, and now the immigration issue is a big issue right now, as you know. Okay, some landmark cases in another category are gay rights. In 2003, the Lawrence v. Texas case, state law may not ban sexual relations between same-sex partners. That's in 2003. And then in 2000, the Boy Scouts of America case, it says a private organization may ban gays from membership. All right, gays in the Constitution. All right. People on both sides of the gay marriage issue gather in front of a California court while it considers arguments about a voter-backed ban on same-sex. Here's our picture. Pretty heated discussions here.